We restructured this business owner's debt by 80%, from $600,000 down to just $120,000. At Mackay Goodwin, we've helped hundreds of Australian businesses do the exact same thing using a small business restructure. It keeps the business trading and allows them to come to an arrangement with creditors about the debt by changing the amount, timing, or way the debt is meant to be paid, all with the aim of keeping the business still operating. But where did the SBR come from? How did debt restructuring evolve? And when did people first start doing it? This is the history of debt restructuring. Formal systems of this exist worldwide. In the UK, there's a company voluntary arrangement. In the United States, there's a Chapter 11 bankruptcy. And in France, there's the safeguard procedure. But people have been restructuring debt for a very long time, long before they appeared in laws. Archaeologists have found evidence of this as far back as 3500 BC. Clay tokens have been found near southern Iraq showing evidence of people accounting for goods. Impressions on the outside listed what was owed, and the sealed packet functioned like a contract for goods to be delivered later. In some instances, renegotiation occurred when someone couldn't fulfill what was agreed upon and a compromise was created. But then we move forward another 200 years to 1700 BCE in southern Iraq, ancient Babylon. When the new king took the throne, he announced a clean slate. So what did that wipe out? Usually personal loans in silver or barley, everyday debts families owed at the time. It was pretty common in those times to borrow and negotiate repayment after a harvest. However, if there was a bad harvest for some reason, floods, drought or disease, people were unable to repay their debts and often ended up paying high interest rates or offering themselves up as slaves. A bit different from what people face these days. So as a result of this clean slate, creditors had to tear up those IOUs. Families got their relatives back from debt bondage and people could return to their fields and jobs. The goal was to reset and stop the debt from spiraling to stabilise the economy. Now, this next bit isn't exactly about restructuring debt, but it does outline how people stopped being enslaved if they defaulted on loans. In Athens 594 BCE, lawmaker Solon brought in Sasakhtia? It stopped the practice of enslaving those who defaulted on any payments. Athens was heading towards a bit of a crisis, with an evolving division between the poor and the rich. Sasakhtia was an attempt to reset that division. A few centuries later, Rome followed the same direction in 326 BCE for similar reasons with Lex Poetia Papiria, which essentially abolished nexum, where your body was the collateral. From then on, creditors had to chase the property and not the person for slavery. So as we mentioned earlier, these aren't exactly a debt restructure, but it did set the scene for cessio bonorum in the 1st century BCE, which essentially means the surrender of goods. It allowed a debtor to hand over assets to be liquidated while allowing them to continue living freely by avoiding imprisonment. Now that's a debt restructure. Now coming into the modern era a little bit, in early modern England, the posture of debts was really tough. The Statute of Bankruptcy of 1542 targeted debtors with some very hard punishments like imprisonment. But it did introduce the idea of pari passu, paying creditors rate and rate alike, meaning the equal sharing of losses. So if Bob's business owes both the government and Jim's business, both creditors would share the loss. Moving into the late 19th century, with the Companies Act of 1862 and the Joint Stock Companies Arrangement of 1870, judges were allowed to approve compromises with groups of creditors. But this is mainly when a company is already being wound up, not yet letting a business keep trading. Moving along a little further to the Companies Act of 1978. Now this is a real turning point for debt restructures. In section 206 it said if a majority in number representing 3/4 in value agree to any compromise or arrangement, it shall, if sanctioned by the court, be binding. So in plain English, if 75% by value and a majority in number of the creditor class vote yes and the court signs off, the plan binds the whole class, even the no voters. Is the ancestor of what still exists today under Part 26 of the Companies Act 2006. Now into the late 20th century. In the United States in 1978, Chapter 11 bankruptcy was introduced. The moment a business files, there is an automatic pause on lawsuits and collections. This means that businesses can keep running, serving customers and paying staffs, all while they put together a restructuring plan to creditors for a vote. Essentially, it's the keep trading while you sort things out model. Back across to the UK in 1986, two new debt restructuring models have arrived. First is the company voluntary arrangement. The CVA lets directors stay in control and work with a licensed insolvency practitioner to put a deal to creditors. And if creditors agree, the company can continue trading whilst the plan is being actioned. Additionally, there was also administration, where an administrator takes control, intending to rescue the company. Kind of similar to a CVA where a plan is arranged, but the business receives legal protection from creditors in the form of a moratorium. So creditors can't pursue the debts unless the administrator consents or the court gives permission. Now let's move on to Australia. Before 1993, Australia had official management and court schemes of arrangement, but they were just a bit clunky. So in 1993, Australia introduced voluntary administration, where an administrator steps in, an automatic moratorium is imposed, and a decision is made to either liquidate, return control, or enter into a deed of company arrangement. A plan which outlines how the company will address its debts, often being restructured. For larger businesses, voluntary administration worked and is still working, but for smaller businesses, it was just a bit out of reach. So in 2021, the Small Business Restructuring Process was introduced. It lets eligible businesses keep running and stay in control of the directors. And like a DOCA, it lets the company propose a plan to its creditors to address the debts at a restructured amount, and a moratorium is also put in place. Now, there are some eligibility criteria that the business will need to meet to be able to utilise the process, but an SBR offers a much more streamlined and low-cost pathway for businesses dealing with financial stress. So, over the centuries, the story hasn't changed. Economic conditions require adjusting debt, and new laws and practices are introduced to stabilise the conditions. Here at Mackay Goodwin, we've helped thousands of businesses address their debt, many of whom have utilised the Small Business Restructuring Process. If your or your client's business is dealing with financial stress, reach out and let's get it sorted.